let's talk about expert witness designation template. Of course, your expert could be your most important part of your trial. Maybe, maybe not, depending on your trial. But we certainly want to designate them timely and not have them disqualified. So this is going to help us to remember to do that. The first item and option we have is response to requests for disclosure. Of course, this is a way that we could designate our expert, is we receive a request for disclosure that includes a request for our experts. And that's probably the most common way. And keep in mind that when you're responding, you're required to include a report if your expert has one. Now, let's say your expert doesn't have a report, maybe intentionally, maybe they're just not going to have one, they're just going to testify. I recommend in that instance including something if something exists. I'll tell you what I mean. Let's say the expert is a mental health provider and you have a custody case and the mental health provider is going to come and say something about the kids or come say something about your client. I think you should produce the notes of the mental health provider. I had a trial once, and we've learned all this by trial and error, of course, where the other side tried to exclude my expert because my expert had no report, but I had not provided the expert's notes. Now, I was successful in not having my expert excluded, but I had to suffer with a continuance of the trial so that they could get the expert's notes, which of course you couldn't even make out, and then prepare for trial. In that instance, because you really couldn't make them out and I didn't want to end up back in another fight about that, we transcribed the notes for the expert. My office transcribed them and then had the expert look over them and make sure that we did it accurately, because the expert didn't have anyone in his office that could do that service for him. And I just thought, you know what, that'll be the next objection, right? Is now we can't read the notes. So that's my tip to you, is even though you don't have a formal report, you may be required to provide something, and if you do, you'll just eliminate their opportunity to object to that. Because, you know, you have a great expert, they're not going to want them to testify, so they're going to be looking for a reason. If you have not received a request for disclosure, you're still required to designate your experts. So look at the rules. It will depend on if you're the petitioner or the respondent on how many days ahead of trial you have to do this, but it's typically, I think, 120 days is the broadest one. Well, in family law, sometimes we don't even have 120 days notice between the filing of the lawsuit and the trial. So let's say that happens to you. You have no request for disclosure, your expert deadline is passed because it wasn't physically possible to meet it. What you should do in that instance is our third tab here. You need to file for leave of court for late filing. And I recommend doing that at the same time, and here's our example of that, exactly the scenario that we just laid out. You'll want to do that at the same time you designate. So just designate as fast as you can, and when you file your designation, file the motion for leave for late filing. Now, why am I doing that? Why am I not waiting until I get permission, basically, to have my motion granted? The reason that I'm going ahead and designating along with my motion for late filing is their whole argument and the whole reason for the rule is they need a lot of notice. So the more notice I can give them of this expert, the better. Because the idea is we don't want to be surprised at trial. They want to have time to take their deposition or to get their own expert to say the opposite thing. So once you know your time is ticking, the best policy is to go ahead and designate as quick as you can, and then you can just file your motion. And I don't always even set the motion. Sometimes I just set the motion for trial, because I think in truth no one's really going to object, but you have to protect yourself because it is technically late. So often I'll file my motion for leave to file late, and I'll go ahead and set it for trial, and I'll go ahead and designate, and in truth they still have 3 months, and that ends up being plenty of time. So that's a way to procedurally protect yourself and get your designation done. And that is our template on expert witness designation.